Assalamualaikum warahmatullahi wabarakatuh. Good morning everyone. It's nice to see you. First of all, let me introduce myself. My name is Nanda Kurnia from Faculty of Law, University of Lampung. Today I'm going to show you to explain the role of state attorney in returning the state laws against the heritage of criminal actors of corruption through civil law, judgment study number 4/PT.G/2017/PNKU. The aim of this research is to know and analyze the authority and the role of state attorney in the region of financial laws of the country in Indonesia. Corruption in Indonesia has become an act that is detrimental to state finance and destroying the nation's morals. These acts of corruption have an impact on hampering the country's economy and development. Perpetrators of criminal acts of corruption must be criminally responsible. The demand for the public prosecutor's region of state finance was not stopped, even though the corruption defendant died. However, the legal process was continued with filing a civil suit by the state attorney against defendant's heir. The obligation of the heirs to pay debt of the beneficiary as stipulated in Article 1100 of the Civil Code, and the person can be held accountable for the property is under his control as affirmed by Article 1367 of the Civil Code, is the basis for general provisions on the region of state finance by heirs of corruption crime defendant. Article 33 of the PTPK Act states that if a suspect dies during the investigation, where there has been a lost state finance, the investigation will immediately submit the case files resulting from the investigation to the state attorney or submit it to the injured agency to file a civil suit against the heir. One of the legal action in order to set state losses by state attorney was when the North Lampung District Attorney sued their Amiruddin, who was a salaried officer at the Agriculture and Livestock Service Office of North Lampung Regency. Based on the audit result report of the Republic of Indonesia Audit Agency, representative Lampung Province, on August 2014, it was clear there was a state loss during the action of the convicted person Supriyanta with Amiruddin in the amount 1.3 billion rupiah. In the research method, despite of research is normative empirical research with descriptive research type, the approach to the problem is the applied law approach. The data used are primary in this study obtained by the interview method. Observations are used to clarify the required data and secondary data from primary legal materials and secondary materials. This research using a qualitative data analysis. Result and discussion. The first one is the authority of attorney as state attorney in returning state losses to heirs of corruption crimes. The death of Amiruddin was a legal event that had legal consequence, namely the emergence of inheritance rights on the heirs, are formulated in Article 830 of the Civil Code. The legal basis for inheritance is inheritance only takes place because of death. Related to the death of suspect of criminal act corruption, Article 33 of the PTPK Act instruction investigator to immediately submit the case files resulting from the investigation to the state attorney or aggrieved agency to file a civil suit against the heirs. In a connection with the forms of authority of the State Attorney Office in resolving a civil state administration case, Article 30 of Law on the Prosecutions establishes for powers, namely law enforcement, legal aid, legal service, and legal considerations. The authority of State Attorney is not in line with the Attorney General's regulations, which state that the formation of the junior Attorney General for civil and state administrations, where in unit is to play a role in saving and recovering finance and asset of the country. Therefore, the death of the late Amiruddin does not mean the state laws cannot be recovered. The PT Act provides a way for the state through the state attorney to extend state finance. The second discussion is the role of state attorney in the civil lawsuit process against heirs of corruption crimes. As the attorney for the North Lampung Regency, state attorney has contacted and invited the heirs 3 times to settle lawsuit deliberately. However, because there is no clarity and good faith, where a superior power attorney from the head of North Lampung District Prosecutor's Office, the state prosecutor has submitted his lawsuit to the Kota-Bumi District Court. The legal basis is Article 1100 of Civil Code, which confirms the obligations of the heirs to pay the debt of the heirs, and the Article 1367 of the Civil Code, which confirms the responsibility for action against the law because of the people under his control or the property under his control. The prosecutor used decision of the corruption court at Tanjung Karang District Court, which stated that the late Amiruddin and his friend Supriyanta legally and convincingly committed a criminal act of corruption as the basis for an action against law. The state attorney presented witness to corroborate his lawsuit. The state attorney also includes evidence of certificate of money depositing into the state treasury through Bank Lampung, which was deposited by the late Amiruddin during investigation process of 260 million. Thus, the case still had not fulfilled his obligation to pay state losses of 340 million rupiah. Kota-Bumi District Court in case granted a part of the lawsuit of the State Attorney Office. The panel judges decided that the late Amiruddin has acted against the law and punished the heirs, namely defendant 1 and defendant 2, to pay compensation for the state losses of the North Lampung Regency government of 340 million rupiah jointly and severally. The panel of judges rejected the plaintiff's claim for the rest. In the public law, the prosecutors has a role in investigators and public prosecutors. In contrast, in the realm of private law, the prosecutors has the role of state lawyer who represent the state outside and inside the court, both as plaintiff and defendant. The point in my conclusion is this: the first, state attorney in Indonesia have the authority to provide legal assistance to the regional government of North Lampung Regency to sue the heirs of the late Amiruddin to recover losses. This authority is regulated in Article 30, the Law of Prosecutor's Office, Article 18, Paragraph 1, letter B, and Article 32 and 33, Law of Number 31 of 1919, in conjunction with Law Number 20 of 2001 concerning the eradication of corruption crimes. The second, the role of prosecutor is in Indonesia in private law as a state attorney who represent the state outside in court both as plaintiff and defendant, based on a superior attorney's power. As a party to the civil case, the state attorney is also subject to procedural provisions enforced in Indonesia. In my last statement is the state attorney in Indonesia has the authority to provide legal assistance to carry out law enforcement and role state attorney who represent the state outside and in court, both a plaintiff and defendant based on superior power of attorney. The authority and the role of the state attorney office can be identified by reviewing the Kota Bumi District Court Decision Number 4/P-G/2017/PNKB. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.